Ebuja kwabon from like black media. Ebuja ene asema abane nyasem ketua. Ne tia wotwem na ne say ebuja lawyers bi aka ho abuma ene omaful simple kese ewo platform team legal wife platform so ebuja nsema wo mo ka no enyasem ketua. Na judges no ebuja ebi ni Ghana ha say and the business so Ghana had no money afro team legal wife for platform and some more can said there must be a review judgment judge what now Mama could just say why not for do bruni presela any that the lumber a woman seven son almost said there must be a review on that ruling now a near maybe one more musu judge and a kaya and young kura na sebi tiasia and shed muntino there must be a review on that passing judgment. And no nebusia omubu afuye pa wo hwese ne omo kana enka ya ye say wo se sebi omutimi sorry ana say ya ye say wo mo be sorry korampo na oma twe protest kese pa de ama ma me akosia say wa na afenso no say ombetu na monfoforo bi na omo nso asole aye demonstration ene anhwa lawyers no say no mani abere omo kasa no enya nwanwa korampo say a time to come korampo no metima organize a demonstration against a year judgment ya echo so busia and some do can be pa wo mon shemu no say we say the antiase nhede nim ka no nkodi nsem no nchiremu ene afofora lawyers yi eka ye MSC ye abuja baby a wo hwe me bia wo haw ne amane kodan na bia da eda wo so bia no bomode se oni me bedi nkomo ye de samna nwanwaso bi aba e friend se eye sika kokko na gold samna wo haw bia da eda wo so bia wo hia sa samna we se bi afi wo ye bema wo hwe me wo bema sam wo pom bema ye ketwa brabeji bula matali eduro bi na wo bema enye kese watimi abo adwuma so ache e wo empem ye de akwankyere bi aba abuja no ye hwehwe wo hyebrim a ye friend se mpelifo akwankyere ana se wo betima friend back to sender onipa bi ha onipa bi tata wato bet e won ho se wo sanity bi obeku bomode so be fa numbers na egu screen ase na woni mi akasa me hwehwe wo hyebere mu hwi a na bomode se me kire wo ne obeye
the deceased and then Mama Kusia were legally married or there was the existence of a civil marriage between them, then whatever transpired between the second defendant and the deceased person could have been immaterial. A man sana the whole claim said no witness the evidence near credible all those things. Once a judge needed to say there was a civil marriage, and whatever they did would have been null and void.
Yeah.
So even if it was any parents na nkasa kwam na neti ho, and I say odo any parents ni no more testify to the existence of sa customary marriage na it would have been immaterial. So nipa na evidence was given weight only on the premise that marriage certificate wanje antu.
And it was intentional. It's a very much
exactly. So that's why we say this is a biblical King Solomon type of judgment, just in the interest of peace and not justice.
Yeah, and I genuinely believe she's a very die-hard Daddy Lumba's fan, the judge, and wanted to literally bring what she thought was peace. So nobody goes to court for peace, and you're not thinking about the implication of that judgment on her assets. And I think if anybody, and her rights, to me, the only person who really, and people say that Marcus Osewa did not lose in this battle because there was two claims. She said that she was the only wife, and the defendant said she was not a wife and that she was the only wife. So in all fairness, both parties did not win part of their case. So she was a wife, but she's a wife under customary law. And this one is recognized as a wife under the customary law. So essentially, it was a situation of 50-50. However, the problem you have here with this particular judgment is that Marcus Osewa is once again the victim, and once again the one who is asked to compromise in a situation she did not create. She did not come to Ghana as a married woman to find a second partner for her husband. Her husband deceived her, lied to her, and decided to engage in and set up a new family with another woman. And under no circumstances did even the judge look at the equitable law, which Ghana, you can't look at common law and not look at equity. And the situation is that the judge incorrectly seeks to look at desertion, which has got this is not a desertion issue in any event. But anyway, she does not look at the behavior and what the second defendant and the deceased caused to the plaintiff. And in her, and so it was purely on her feelings, the judge's feelings, because if this was in a UK court, and I keep saying this, the judges will say if you come and you ask for relief, you have to come with clean hands. If this relationship was started in hiding, and they brought up the whole issue of that Lumba took Adobroni to see influential people and was not high. But where was Akosha Sewa? Not around. It's not like Akosha Sewa and Lumba and Adobroni went to see the president, or that is not what happened. This was an issue of deceit. This was an issue of lies, which is an issue of the conduct of the husband having significant impact on her, not just during, but also after his death. And the sad thing that people realize is even in like America and the UK, the judge will penalize the deceased and those around for this, because the judge is very clear. You have to come with clean hands. And to me, it's really random that Ghana, a Christian country, does not understand that you cannot ask to penalize the victim twice. It really just surprises me. And I think even after Marcos Osewa, people think Marcos Osewa's judgment is actually a win for men. I want to say something. It is a big loss for men, because I think if women now need to stand up and say we want a whole rewrite of the rules, there is no way you say that a man can marry have a second wife, a woman can't. And then you think a man can secretly have a second wife and that would be recognized, that if it's customary. No, the law has to be clear, it has to be just, and it has to be fair. Well, if something is not correct, it's not fair for one party, cannot be fair for the other. So I think this is a huge thing for us. I think it's open, is what it has done is it should this fight in women to say, for too long, Ghanaian men have been abusing their wife, and they have been using women and taking their youth from them. And then when they're 50, 60, they leave the women, and then they go and find a younger person, and then they stop taking care of their responsibility, and that is supposed to be acceptable. And we need to change the culture and the belief and the concept that this is okay. It's not okay. And the concept that they rely on the common law, but fail to look at one of the key aspects of common law, which is equity. You have to come with clean hands.
Yeah, you see, what I have observed is that this case, there was no winner and there was no loser. If indeed the second defendant felt she was a winner, she was not. Because you went to court with a counterclaim that the court should declare you as the only surviving spouse at the time of the person's death. That was your first relief, and it was shut down. You went to court claiming that there was divorce between the plaintiff and the deceased person. You couldn't prove it. It was shut down. So if that becomes the case, it means you went for 100%. They've given you 50. The other person also went for 100%. They've given her 50. Now you are both recognized as spouses. So why would you be so much excited if at the back of your mind wouldn't say our you understand? It beats my imagination why the other side are jubilating about this judgment as if say it is so much in their favor. No, that is what you
very clear. She was never a wife, and she's
exactly.
fully. And I will make this. The reason why she's jubilating is she's not a wife.
Exactly.
Never, and she knows she's not a wife, and she knows she's been able to lie her
Maneuver her
way,
way.
lie
Yes.
her way to get something. And so anything for her is a win because she's come to court with what you can only describe as a with lies, and she's just been consistent with their lies. I'm not saying this, and I'm not saying allegedly. I think it is very, to me, it is very clear through the evidence that you know, even in our own custom and tradition, she cannot be recognized as a wife because everything that they did in his own house, not her house, the main family, the actual family were not invited. Probably, you know, no pictures. It just, to me, there is no.
It was just a sham.
It's a sham. It's
Or it
absolutely.
never happened at all.
It never happened at all. Never. Before this judgment came out, around October, end of October, I remember saying to everybody, "Oh, I think it must have been knocking." You know, I remember saying, "Oh, it was knocking." From the information, it was knocking. You know what men do when they get you pregnant? It's like, oh, that's what they do, is knocking. And one person that I would say has been consistent in everything she said, and it comes out to be true because the document, the letter that came out later on was aligned with what she was saying. She just recently, out of anger for the judgment, and she has been very much trying to say, "Oh, come on, let both women should be recognized."
Aisha Modi.
Yes, Aisha. I don't want to say mention names, but I have to be very clear that
I would want to ask a question, please.
I want to be very clear that it's not what she said. I've always had these feelings about when you look at information, you think, oh, this is, then I look at the different evidence and the lack of evidence, the lack of pictures, the lack of everything. And I'm thinking, there was nothing. There was, to the point that even recently, Daddy Lumba's marriage to the white woman, there's pictures and videos.
Okay, just me. Kindly ask your question then. Others
Okay, I want to ask what is the implication of this judgment on future cases? Because I would just say I can't think far about most of the cases. I've had the privilege to read some of the paragraphs, and to me, with the witnesses, certain things are not adding up. Like the one we earlier discussed, after cross-examination, a judge would commend a witness, and at the end of the day, it appears in the judgment. It still baffles my mind. And secondly, can we petition the Chief Justice about this whole case? Because it's not only
Ghana.
about the women.
Yeah, if you're based in Ghana, I think you should do it. I mean, I try to, but they block emails from outside. I've tried to send a few things to them, but it's been blocked.
I'm not in Ghana, but I'm a Ghanaian, but I'm not in Ghana.
So yeah,
I'm just asking the future implication of this whole judgment on other cases.
I want to be very clear. It's from the High Court, so lower courts will rely on it. The High Court can also rely on it. So the future implication of this, until the judgment is overturned, it is law. And individuals like Odoboni could rely on it to bring the evidential burden down in order to be recognized also as a wife when essentially the person that they are in a relationship dies. So what is the impact? The impact is it's now law, and people can rely on it in seeking to win a case against a wife.
And can I add small?
I'm coming there.
Yeah.
The other bit too is that, you see, the aspect about that section 161 matter in respect of foreign documents and certification and all those things. I think there are not a lot of cases on it in our jurisprudence. So this case is likely to be reported. And once it is reported, until maybe a superior court give a judgment that contradicts this one, it will continue to be the current position. Unless, as we are going to appeal, if we should go on appeal and then the Court of Appeal makes certain findings on it, then it will lose its weight. You see that the recent documents that are being circulated has got a Lands Commission stamp on it. Until recently, I think as late as last year, all the documents a dan allocation note announces a tenancy agreement in there. If we are going to use it in court as evidence, that's one for Lands Commission and Kutia stamp duty. The law then was that it shouldn't be admitted at all. So imagine say, say as I say, dear, or any amount allocation, be everything should say, dear. Now they people and be court, just on the basis say one for Lands Commission and Koji stamp and to stamp duty. And the court will not admit a document. Yeah, admit it. So I mean say, who claim say assassin. But you have come to court without showing the judge any document, even though one attached document in it is believed send a judge way your documents now or say because certification to something means we have come to court without certificate. That used to be the position when it comes to land matters until Supreme Court in opportunity, and then
Think lawyer is off.
basis say even though document but one fan call for stamping he won't lose in the case. See, he made an observation or make a comment once you bring a document and it has not been stamped, you should be granted leave to go and stamp it and bring it. And I say a pay farmer registrar no one assessment now amount tax no at the cost registry so that document can be relied on. But ask yourself, until such decision by and how many cases have people lost only on the ground say those are the kind of implications we are likely to suffer until say maybe a superior court will overturn some of those principles in our case we are establishing.
Yeah.
David, can I say something?
Can I say first, please?
Okay.
Okay. Just win. My statement is one. Based on what the judge said, saying Odobroni's witness statements are the most credible one that it carried weight. It means that one say if say waware never say bibinti umbe unkunu na say ukunu etumi ni obi ekwa ha fa piwa dachi no say onipa ne na wo anase dempo ekokota no obi bedi adanse empo say o me ko waware okoge ona ware ene ukunu na one without pictures, without videos impo because of that dance they no did the same dance yet is the court is bound to accept it. But Joe Balami, am I wrong or right?
Yeah, as it stands now, that is the case.
Oh, and so that's one serious implication currently. Oh no, you are serious with your husband. You people are in a serious marriage. But obibe to me ukunu pie no ni ukunu bobo koba wanyim 2 wanyim 3 because of why ukunu pie no that eba ne say enkwala na ukunu ma no mutumi kaka so mutumi kobo ni sa nyuma ya asema ba abre no nti o de for your future MP Kakana bese miche Jasmine no. Yes, madam.
Let me, if I could have another chance to ask another question, then I go off. So could it be that there are cases in Ghana that didn't go well and it's now law that other lower courts are depending on that to pass judgment? So then I think there need to be review in some of the judgment that has been passed because we are building a country. We are not here to gag our citizens not to seek for justice when they are looking for it.
Judgment
Do
bar,
you get me?
there are two ways. One, say onipa na party to the suit, and as a party a aggrieved person, and as in we win, you know. So I go vote two way appeal is still in effect. Whether bad or whether good or is still in effect. Now, second option also say a higher court and as a Supreme Court my judgment there. Say oh maybe say based on one understand once they interpret the law, the constitution itself into to me usually you know to me there are some conflicting laws be or judgments be or Ghana, you understand, but usually you know two no clash here. The best thing is you take it to the Supreme Court for interpretation. And Supreme Court need to need the right way. And by judgment, no say a banis and I was appeal. No say far. You have other ways of remedies. And say appeal. No say it will be Tony in the from the bad judgment to a good judgment. Now the good judgment is in force. So what you say, and the bad judgment, you know, I don't know though. I mean, say Joe Balami Mona, any Jumana Mona bit me, I explain you how, but say so far as I judgment done, someone can use it one day. I don't know if say it's true or not true, but good judgment, you know, carry more like the new judgment, you know, over the old one, will carry more weight until say there is a new statement again from the higher courts. That's what Joe Balami or Jumana Pacho, if you people have any light to throw on it.
You see, a judgment is a judgment. Whether good or bad is your opinion. You get it. So once the judgment is out and until the point where a new case comes up and then the judges get opportunity to remedy or go contrary to that existing principle, it will be in force. You can decide to disagree with it or call it bad judgment, but that is the case. So yeah, and you have to mind you, our laws keep revolving. Law is static; it is growing day in day out. The circumstance of the case, any this say law in a cake and answer aye. Let me take you through spousal property laws. You see, from 1970s neighbor. Even prior to that, you know, now you who a man say or me a bema asset. So who are or you can work asset as a man. So a woman was not in the position of having any property in Ghana. So they say because who are you can property. But over time, no, it got to a point when they said no, that law is a bad law. So let's get to a point where a woman can prove say or no property na me a man share. So you're moving from say or buy a property to a point where she can equally have a property. So any says to me prove say see dino na me to iron rods no to cementa. Then what me prove contribution. It's in a day, your man share. And this also cause for some time. Then you go to a point in your case no contribution in any iska or baby how a housewife, but or a very supportive on where they or her or your homework or any kunuda and a whole lot of things. This anya manema na oyen and no manu no opportunity ma when you're holding any peace of mind at the concentrate here no any ska the aqua property. So the contribution should no longer be looked from monetary perspective. So in a sad a change here cause our point in say contribution no and is can and still now the circle and say okay sanity there near Cheney. And then from 2012 and then they started mensa and about saying 50-50. So any day once I only need an hour no, that is when the 50-50 principle came in. It was and then we've gotten to a point where they are now saying that even though 50-50 no, there should be variations. If you are not able to loan in a DTI and a DSR property, when you enter a loan in your so day in day out no, the law keeps revolving. It as it stands now no, what the judge has done no, will stand until say case forever. Now Oma make a pronouncement And I say someone can go to Supreme Court to seek for proper interpretation of Section 161 of the Evidence Act. I say foreign documents must be certified. Then the Supreme Court will make a pronouncement on it. Say, as at the time you make this act, what was the intent? So, what was the intent of the lawmakers? Now, is that intent still relevant? And I say irrelevant. So, the bottom line is that the judgment will stand as it stands now. But say a good and a bad, any opinion, you can decide to see it as such, because the one who benefited from it, one who say a good judgment. So let's look at it from that perspective. Say until say another case whereby and I see a better appeal, they are overturning, and I say another case whereby I'm a bold judge, I take it position a different from this one. Then no about the current position of the law. So
Lawyer Pacho,
Lawyer Joe, I think I'll be waiting.
on the certification.
Can I make the opinion? I think
Mr. 1 minute. Why?
two people have come to close.
Hi. Hello. I'm here for Mr. Mon power tap na mon share. Mr. Mbebre. Mon give to lawyers, no me lawyers, mon give to your mama why. Me the time ebe to so Mr. Mo ukasa we ape. Now we see upesa sign baswa. Now I sign request because request bebre 9 and yefe some bejina siesa na ebia on drop it because more no more channel o from one enye Mr. Me the time we two be so wadaroma sahana wo cramp high like o platform cramp ti asie na sika kra na wasaba madam wase.
Okay, any mami see. Why? Na oh, me umu ame basro. Why, Pacho?
before I interjected.
Oh no, I'm say future MP.
I was saying that lawyer, please, are you part of the case or something? I was just going by the way you were just having a discussion. I don't have practice in some imagine. When I wrote, say I agree. I thought the judgment was fair. Somebody was insulting me for just saying that, but that does not change my position because that's the point. Having an open discussion.
But I do also future
mommy.
Okay.
So, lawyer, I heard something. What did you say you were part of the case, please? I didn't hear you.
Personally, I'm not in Lawyer Kusi's firm, so I wasn't part.
That's fine. Me myself, my friend who is going to UTV, my classmate. I spoke with him when the judgment came that they should go for appeal. He said they were going for appeal. Well, they have 5 grounds of appeal. They got on Monday. That was on Friday, and I spoke on Saturday. But I think when I read the judgment, I kind of my position changed a bit. I'm not a practicing lawyer, but I have a LLB and a master's. I live in the UK. Okay, so I read the judgment. I just took time those that I can understand and maybe talk about it when I hear people discuss. When I read it, because people are saying the badges, I don't know. Because if you find the ratio or the holding of the judge, I don't think it was about somebody can marry under civil law and somebody can claim to be a wife, and I don't think so. The first one for the case, there was a counterclaim. Okay, the first part of the case was whether Miss Akosia, Mame Akosia in the Germany from Germany, he's a legal wife, he's the only sole wife, he should be allowed to do the canal or something like that. Okay, so that was the question, and then the judge said because it's you are the plaintiff, you have to prove it. On the balance of probability, is it more likely than not? So you have to prove it with evidence, facts. And because there's a conflict of law, Germany, he showed the procedure under the Evidence Act. What you have to do, go into the German, what they could bring him or something, the registrar, for certification, taking it to the Ghana consulate in Germany. Whether that was, this is based on the Evidence Act and the foreign law, you quoted a section and the foreign document, something like that. So I thought everything, the pronouncement, everything was based on the law. Yeah, the judge make reference to case law plus the Evidence Act, 1985. So, and then when it wasn't been, according to the judge, it wasn't established because of, extra, there was some conflicting date and things like that. The judge did not accept it. That's basically, he didn't accept it. And when she didn't accept it, now he has to look at the other part. because there was a counter claim that although Bruni said he was married to that Lumba girl, and the judge has to first look at Mama Kosia's marriage, which was done in 1991, which was under customary law. That was customary, it wasn't ordinance. The one was done in Ghana. She applied it. In fact, there was a contradiction that the marriage has been divorced. But she said no, they have to go through the proper channel according to the expert witness from the customary part. They have to go there, the family has to meet, and they didn't do all those things. And the Busafeni even said she wasn't present, but she knew that she was been divorced. So the judge also did not accept those claims. And then he said no, she's still married, she's married under the customary. Okay? And then she had to look at Odo Bruni, and based on expert witness, she said, okay, they had a marriage, and they were saying that they had it outside of that Lumba. It wasn't that Lumba's house, was that Lumba's house or something like that. It has to be their wife's house according to the custom. And she was claiming that because of event centers and things like this, he made a claim. I don't know if they go to appeal and they don't agree to that, that's fine. And then she also made a marriage by conduct according to the expert witness claim. Conduct as in the fact that you live with the wife for cohabiting for many years, and then the children, the family are aware. In fact, he said that Lumbe's sister and there's called that lady Marcel Connor for all sorts of names on record. It was part of the exhibit. Okay, so based on all these things and some of the witnesses of the Mamia Kusia, there were evidence, there were contradictions in the evidence. Okay, I don't have time. I would have gone through it. This is why I came up. Okay. So based on that, I want to conclude. Lawyer, I want to conclude. Based on all those things, she said they were customers. They were married to Odobro, because that Lumba on record. I've even said it. My wife is and this. Both of them been talked about, and that would have been the intent of that Lumba. And based on the customer, you can marry more than one. So if she was applying customary law, then that was why she said both of them. If it was ordinance, there was no way it should have. If that certificates were accepted, there was no way it should have made that judgment. It wouldn't have even reached there, like lawyer Joe said earlier. Okay, so I'm trying to. If you say what's the ratio of this case? What are you gonna? I don't think that the ratio says you can do this. The first ratio is you need evidence. You have to prove it when you are coming to the plaintiff. And then if it's foreign law, you have to come with this. You have to follow this procedure. And then under customary, that by conduct and the venue does not matter. I will say those are the ratios. So if you go to case court like that, similarly, and you prove that you were married before, it will not go this far. So okay, that's my point of view. Yeah, you can come in. Okay, thank you. I think you've made various assumptions in your submissions. And so, first of all, assumption. No, sorry. No. Please let me finish now. You've made so when I say submission, it's a terminology that I'm using. Okay, submissions insofar as the statements that you have made to me to explain why you believe that the judgment is fair, and you have every right to your opinion. What I would say is, from a person who has legal background, I think the judgment is misleading insofar as application of the Evidence Act. The Evidence Act does not say under any circumstances that you must, and if you don't go through this process, then the judge should not accept the document. That is not what the Evidence Act stipulates. The Evidence Act, in my opinion, from the reading, provides guidelines and guidance insofar as what you should do to authenticate the documentation. But the Evidence Act in itself also goes, if you go through the bit that she quoted, but then what she did not do is quote the other sections within the Evidence Act that was being relevant to the argument that we are bringing today. Now, there may be circumstances in which you cannot follow all the process, and where you can't, and she, in a sense, go into that part, but then she does not really commit herself, because she says that the lawyer failed to show her evidence that he had tried, and lawyer Kwesi is saying that's not true. She was aware that I had tried, and I even asked specifically to call the witness from the embassy to give, and for her to summon a witness from the embassy to give evidence in court. So we can't make assumption as to who, whether her side is right or lawyer Kwesi's side is right. What I can say from observing the trial and observing the conduct and the things that were said after each day, what I can say to you is that there was clear intention, even before the case management conference, that lawyer Kwesi was going to call a witness or planned to call a witness from the embassy.
So the fact that at some point during the providing the detail of the fact that he was going to call 4 witnesses, and one of them was going to be someone from the embassy, until the final day where witnesses stood up, something happened that transpired in court, which hopefully Lawyer Christie would be able to have from the transcript, that suggests that the judge, and actually in the judge's own judgment, says that, about the fact that, the comment around getting a witness from the embassy. Okay. So I think we are making so much assumptions to suggest that the Evidence Act stipulates clearly that the plaintiff must follow these processes. Otherwise, the judge cannot accept the evidence. That is not the case. This is the standards in which the judge expects it, but in certain circumstances, the judge can allow if this process was followed. And actually, there are different processes for original documents and also certified copies. And it appears from the evidence that Lawyer Christie has provided is that the initial evidence that he submitted was certified copies. Okay, and then the judge requested during the hearing for the original because the other party had asked that they wanted to see the original. It was at that point that Lawyer Christie was trying in speed of few days to get the original marriage certificate to the judge. Clearly, there is clearly a misunderstanding insofar as how a marriage certificate should look that comes from Germany, and the judge admits that herself. And I also believe that the inconsistencies that has been discussed by the other parties' lawyers, to me, shows a level of ignorance as well on their end. And you can excuse that by the fact that there was no expert witness in court. But the level of ignorance insofar as the different names, insofar as the different dates, that, it is either they genuinely did not understand the difference between an original and certified copies, and that those original and certified copies will have different dates, or they intentionally misled the court. But I want to believe that there was a mistake. So to me, I think it was a mistake. I'm going to admit that maybe it was a mistake on their end. But the fact that there were so many assumptions wrongly made suggests that in the interest of justice, the judges should have taken further steps to better understand the procedures and the process that she was confused by, clearly. And also in the interest of justice, and maybe she should have adjourned the case and made clear orders on the plaintiff on the basis that she cannot use her discretion to accept the documents, and made clear orders for the plaintiff to provide further information that will allow her to confirm that these are original documentations. So, and equally, the fact that the judge decided to refuse the plaintiff's request for an injunction to allow the case to be properly litigated, and then suggested that she would do everything in her power to hear the case within 4 weeks, and then hold or expect the plaintiff to jump through so many hoops, which requires parties that he has no control over, i.e. the embassy based in Germany. You're talking about foreign documents and individuals outside of Ghana. So under those circumstances, I do think that there was procedural irregularity. I don't think it was fair. And that is the reasons why I think, in the interest of justice, I would put an appeal, and I would stipulate all those grounds, and I would and more. I have loads more grounds that I would bring into an appeal, and hopefully the courts will see, in the interest of justice was not served in this particular judgment. So you have every right to essentially hold the view, especially without legal background, to look at it and say, hey, on the face of it, this case appears to be, her decision appears to be backed by case law and also and statute, and therefore I think this was fair. I don't believe so. I don't even believe that the case law that some of the cases she relied on actually was fit for the particular circumstance in which she was looking at. I equally believe that she misunderstood the expert witness testimony and misapplied it. So, yeah, for the purpose of moving on with this particular discussions, I think there's so many reasons why I don't agree with that submission. But you have every right to have those submissions.
Okay, thank you. I want to ask one simple question.
Godfather, please let me come
Okay.
My question has to do with the certification. I think that Lawyer Joe, you were mentioning the Evidence Act, but I listened to an interview that was granted by one of Mama Sewe's family members, who said they actually went to the Ghana embassy in Germany for them to put, the necessary stamp or certification on the marriage set. But the feedback they got was that they are more like strangers in somebody's land to come and certify their documents. So basically, let's say, lawyer, you have a child and you know that you gave birth to this child on the 5th of December. That's your child. And then I come in to tell you that, no, lawyer, the date is not fit. It may be 7th. So what Ghana Embassy in Germany were trying to tell the family that we are not in a position to certify a document that the mother country or the destination country has issued. And that was the feedback they got. So they didn't have any other choice than to bring that same document to the German embassy here in Ghana for them to do the certification. So I don't know. The Evidence Act, does it really state which institutions are supposed to certify what before we bring them in? Because from my understanding, they did all that they could do. And still they are saying that their documents are not accepted. So is there institutions listed for all this certification to be done?
Mr. Joe Balami or Jumana Silva, any of you can take it up.
Read the section 161, 1 and 2. It specifies the manner in which, and then the authorities that are supposed to do the certification. And then if you look at what has been circulating today, or I have come across it this evening, and it looks like Lawyer Kusi did all those things. He put in the application as far back as 3rd November. Only that the case was in a haste, and maybe as at the time he was filing his evidence or his witness statement, he had not gotten the feedback from them. And so those are some of the things that we believe that what we are seeing, what I have seen today, if those documents were really part of his evidence, then I really think the judge had made up her mind. Other than that, you can't see all those documents we are seeing this evening and still say that you cannot rely on it. Rather, you choose to believe someone's narrative that he was present when the customary marriage was being celebrated. You understand? And so those are some of the reasons why we should truly appeal, and then we see how things will turn out. Because in a situation where cases of this nature, that is why the section 161 make provision for the subsection 3, which is to the effect that in the course of looking at cases of this nature, because of time constraints and the other things, you can gloss over the certification and other things and still admit those signatures as if they are genuine. You understand? But you can't push people to do case on record time and they still won't expect that they go through normal procedures. Like Jumana said, they go through all the processes as if they are using like a year or two to determine the case. So there is luxury of time for you to do whatever is expected of you. And so in the case of this nature, when a time is of essence, I strongly believe you should have relied on the subsection 3 instead of the 1 and 2 to shoot down the documents Kusi tendered.
So, lawyer, my question actually was, so the Ghana embassy in Germany, were they supposed to do the certification for Mama Sewa? Because the family went there and they said they are not in a position to certify a document that more like the destination country has issued. So was it the Ghana embassy in Germany who was supposed to do the certification, or what Mama Sewa did was the right thing? Because I think they came for the certification from the German embassy here in Ghana with, I think, a letter from the consulate or so. So I don't get it. Why did the Ghana embassy in Germany refuse to do the certification for them?
My evidence act is not closer to me right now. I could have read it to you and then we'll decide on that. But whatever be the case, I'm sure what they should have done was to maybe, like the judge mentioned, maybe lead one or two evidences to prove that they have made efforts and this is the results they are receiving from the embassy. Like the way she placed in the judgment that there was no evidence that they have made attempt to get the certification and other things done and were not successful. I don't know if Jimana, you are closer to your evidence that you can look at the section 1 and 2, 1611 and 2, and let's see.
No, I'm not close to it anymore.
What I would,
But I'll get it.
What I would want to add up.
Thank you, lawyers. I think I have to get down for someone to also come up.
Oh, okay. What I want to add up to MPP statement or Joe Balami's explanation was one, based on the section 3, aside accepting it as an evidence in pool, say if the judge didn't want to accept it as genuine crampona, she could have adjourned it and given enough time frame so that they'll go and certificate and finish everything and bring it back well. But she clearing those two options out, she shot herself in the foot. That was a very big mistake. And Nana Kweku or something, Nana Keo is the next person. But I want to ask one question to either Joe Balami. Two questions. But the first question is Joe Balami and Jumana, please respectfully. Is a judge allowed to see a witness or meet a witness in a chambers alone in court before a case?
That is absolutely not acceptable.
Okay, Jumana, your stand.
Recently, let me give you an example.
Okay.
There's a judge who just recently went on retirement.
Mm-hmm.
She was doing a case. He was doing a case that we were part, and then there was this witness we called from Accra.
Mm-hmm.
And then they are classmates. So the day the witness came to court, it was in the morning, and then he didn't even know that it was the same judge he was coming to testify before. So once they are colleagues, he called me and said, "Oh, I'm around, so just come over." And then he went to see him. Then before the judge came to sit, only for us to call the witness. And he said, so you were coming to do this case. Then the judge told us that he has had a conference with the guy this morning. So he doesn't think he is fit to continue with the case. So he has recused himself. We had to send the matter to a different judge. And so if you're a judge and maybe you want to commend the witness, you wait for him to finish everything he's saying. In the presence of all the parties and the other people, you commend him for coming. That's where it ends. Maybe, thank you very much for your time. You have been helpful. Those ones are harmless. It is in the presence of, but then you don't go ahead to congratulate the person and make it look like he has really helped you to make your work easier and all those things. Those are prejudicial comments. So you are not allowed to do that. But I'm not sure. I'm not sure it's going to be on record. That's the thing. And you see, when you are taking a matter to on appeal, it is facts that are on record that will go. So if you say that, okay, the judge met him outside and tapped him in the shoulder and said, "Oh, you have done very well," how will you prove that? You get it?
But he gave an interview and he said that right after. So it was a recorded interview.
And so at that point, Lawyer Kusi should have protested.
No, it was after the judgment that he said the man came out and he said that stuff that you
No,
met
you don't rule out that people brag. People can brag.
Yeah, if you brag, that one there, then it's the judge's duty to at least get you up. That
So
one
it's going to be his word against the judge's word.
simple.
And if the judge believes that she never made those comments, she can actually subpoena him to come to court and cite him
You
for
feel the
contempt.
witness, right?
Yes.
Good.
The judge can, if she try to wait till invite her back court to come and show cause as to why she shouldn't cite you for contempt. You see that when we are here, there are certain things we say it. I don't know how to put it, but we are measured in. Personally, I am measured in the kind of things I say about the judgment, the kind of things I say about the judge. I have cases before her. That one I won't lie about it, and I won't say things that when I am called to come and justify why I shouldn't be cited for contempt, I can't justify myself because every comment I have made on this platform are fair comments. You get it? I've not said anything to incite her. I've not said anything to incriminate her in any way or manner. And once the judgment is out, we are all entitled to make fair comments about it. And so for him to be bragging that hey, the judge said this, then if the judge believes that she never made those comments, obviously my friend, say brabechere, baby cry no ujina, because I know how the court of appeal looks. Maybe a judge is never if you equal out. There is no way they will come into contact with the witness. You understand? The way the building is, maybe I need that is not where the judges pass. Or more, maybe far. It is for them alone, for security purposes. It can't be disclosed here. But Omono firm could be underground. A honum will be any honum. So for you to come out and say, oh, we met our judge in Ukraine who are on Casa or Humpo. You understand? So some of those comments are just meant for people to appear as if say, oh, yeah. People just brag like that. And I'm wondering.
The reason why I think there might be some truth in some of these is that the other side, I don't know, they were very confident to the point that they were calling people saying, are you going to apologize now or are you going to apologize when Thingy wins tomorrow? They very much knew the outcome a few days ago. So that's the reason why, because everybody was saying, how are they so confident? Obviously, we were confident, but we were confident because we know we had the marriage certificate. We're like, whoa, there's no more.
Exactly.
So we were like, so when they were dancing,
already dressed in white.
Yeah. I was thinking how, and so that is I remember even going on to Nana J thingy saying I'm really scared about the outcome. I'm scared about the outcome, and my heart would go, my stomach would go in because I'm like, oh, this is Ghana. I'm scared of the outcome because they were so confident. They were dancing, wearing their clothes, and they knew it was.
Yes, victory. I remember one evening the caption was "Victory is coming."
Yeah.
Victory is coming. They were very sure.
This is the reason why I think social media is making things very clear. Whereas before social media, you never know this. But they knew. Listen, the argument that the argument that going to be in the judgment was already discussed, and they already knew this, and they knew victory was there already. And so there's no way you can tell me, bearing in mind if the certificate had been accepted, that's game over.
Exactly.
There is no way.
The interesting part is that I'm told one of the days the judge said in open court that she's not on social media, so she doesn't see whatever is going on. I don't know how
she lied, Massa. The judgment card shows that Massa she was on social media on my engine.
Let me make something clear also, and I really need to know. You remember that Daddy Lumba when he called, which birthday did he call Odo Bruni to worship her? I thought it was a 59th birthday.
59th. Then the 60th was for
exactly. But the judge's determination suggests that she did that on the same day. So he praised Marcus Asewa on her 60th, and then he praised Odobroni, but that's not true. He praised Odobroni at his 59, and then on the 60th, he praised Marco Hesewa.
One he was in red and one he was in white. These are the two different things.
Exactly. But the judgment, she if you read the judgment, go back, she talked about, he was, publicly on the 60th, and she's mentioning specifically on the 60th for both of them, and actually it's not, it's 59 and 60th.
But these things are trivial. I think Nana can come.
Nana Kuju Pacho, you can talk now. Why? 3 minutes.
Good evening. And
evening.
My question goes to the two lawyers, and maybe be our adventure be our counsel. Supposing say mommy, that's my say what decides say also seeking for legal redress from Dutchland. Being a say maybe or the court and I say the judicial approval. One the defendant no, and in cases so unya a judicial declaration from Germany. Now maybe or you say based on the outcome of the appeal now, everything they are starting a fresh case, and I say it will still fall under what we call res judicata.
Joanna, would you want to try that?
So, I mean, this is a very difficult one because when you obtain a judgment in another country, you have to also go through a registration process. So you have to appoint a lawyer in Ghana and get that judgment registered. But often, the registration of the judgment is often because you want to be able to enforce that particular judgment. Whereas this is different. You've got two conflicting judgments here, both enforceable. How do you enable a court to allow you to register that judgment and enforce it when there's a judgment already in the UK? But in the UK, in Ghana, what I will say, however, is the assets belonging to Daddy Lumba. I don't want to talk too much. I want to keep it to myself because I think there's people here recording. But I will say what I want to say is that, remember, the judgment that has been made in Ghana will only apply to the assets in Ghana. So the stuff in Germany will be protected by any declaration that's made in Germany.
So even if
the other big thing is that,
what did you say, Joe?
I was saying that if you want to institute an action in Germany, who are going to be your defendants and where are they?
Exactly.
Yeah.
So case would you say because she could have started it in Germany, but defendants now in Ghana. You get it. That is why they brought the matter here, for us to apply the Ghanaian law in respect of those declarations she was seeking to affirm. But once these ones has not gotten to a point where they are looking at properties and the other things. So when you get to that side, they will look at it properly and apply the proper law.
And I want to share something also. We said Talo or something, one of the oil companies or drilling offshore companies in Ghana here, they had a problem with this past government. The case went to Supreme Court. The Ghanaian government won. The company were aggrieved. They were saying no, they don't trust the judgment. Like they felt some way. They took that judge. They took their case. They took it to London, UK. Yeah, this year when Mama won, and the new Attorney General went there and they won the case. You understand? And so sometimes some stuff like that can happen though. You understand? Technically also the person is a German. So if the wife says, okay, I'm suing ABCD, or maybe I want to be confirmed as the wife because my document is in Germany and stuff. If she goes to court, you, the person being in Ghana, you too, you knowing that you two are a wife, you can either take up the suit and also add a rejoinder, or try and also seek to be added or something. You understand? Because one, if according to the German courts, they see the certificate and everything, and they say the judgment comes out and it said that okay, fine. There's Akosia Sewa or something. Yeah, Mrs. Akosia Sewa is confirmed as the wife, and the certificate and everything before the courts in Germany, it's true and genuine. She just have to do what Joe Balami said and Jumana said. You just have to just register the judgment here. If you get it registered here, you are done. You understand? Okay. And so that is the other leg she can do.
And maybe be like res judicata. So in case of the case,
so sometimes too, people have tried that thing before. Even though those who tried this, they weren't successful though, but it doesn't bar you from trying it. You get the point? Yeah, you are not bad from trying it though, but people have tried so far. The people I've known or I've heard or said they've tried that sort of game, no, I've not seen someone who has won using that formula though. But the case where like you could see that the other country, the opposition country, took it serious. You understand? So if this case goes to Germany and the wife takes up, okay, fine, my certificate is German, but in Ghana they are saying they said, I don't have any problem. I want Germany to confirm it. Then after that, in court. And so if it's confirmed in court and they said, oh yeah, I'm still the wife, I just have to come to Ghana and register the judgment in Ghana. I'm confirmed as the ordinance wife, married wife, and also the year and everything checks out. You understand? In Germany, and it's a German court. If it comes to Ghana here and you register, it pass through quietly. But the registration, a better drink a crowd, but still no. The moment you get it registered, it's enforceable. But the procedure is the problem.
So I just want to also say something. I totally understand, and I don't really want to go into that because it's such a complicated set of things. But I know that it would be difficult, and it was a very poor precedent if a judgment was to be made in Ghana, somebody goes somewhere else, get a new judgment, and then seek to nullify the judgment in Ghana by imposing the judgment abroad in Ghana. I think that would be just a very complex set of issues with that, and I'm not sure how far that would go. However, someone has just said down here about Lady, I don't know if Lady Apostle is still online, things around speculation online and people believing that everything has gone to Priscilla. I want to be very clear. We're not on properties yet, and so it's hard for us to discuss anything on property basis. But this is the advice that I would give if I was a friend of Priscilla.
So I'll ask Godfather if she should go to German court today. Is it like she's going for a declaration, like the way we go to Supreme Court for declaration, or someone has to be a defendant in that matter?